In this lecture, we will look at the EC legislation and its impact on the rules of interpretation in the UK. Under the European Communities Act 1972, the UK courts are bound, I'm going to use no were bound to interpret the legislation to implement the EC law. European jurisdiction is a civil law jurisdiction which does not take exhaustive approach, unlike the legislation in the UK. Drafting in the civil law jurisprudence and jurisdictions is comparatively simple, with a considerable degree of abstractions. When interpreting the EC law, the UK courts have to take similar approach as to the EU courts to give effect to the EC legislation. Since the UK legislation should also be in conformity, should have been, with the EC legislation, the UK courts take the same approach for the UK legislation. And remember, the purpose of this lecture in relation to EC legislation remains relevant because, as we discussed in one of our earlier lectures, that this is going to be the nature of interpretation for the foreseeable future, unless it is changed by an enactment of the Parliament. Taking the approach in relation to conformity with EC legislation, this inevitably results in the UK courts taking purposive approach more widely. This should also be noted that the decision of the European Court of Justice were binding in the UK and have been influencing the UK legal system and approaches taken by the courts to the interpretation of the legislation. The case of Lister, for example, against Forth Dry Dock and Engineering, is an example that the domestic legislation must be interpreted in line with the EC law. And that's how this jurisprudence developed. In this case, the relevant legislation was the Transfer of Undertakings, Protection of Employment Regulations 1981. This was a statutory instrument, a form of delegated legislation which had implemented an EC directive. In this case, the company's 12 employees were dismissed an hour before the business was transferred to a new owner. The employees were intended to be replaced by a group of employees who were prepared to work for lower salaries. The employees claimed unfair dismissal. The relevant law provided that the transfer shall not terminate the contract of any person employed immediately before the transfer. The question for the court was to decide whether the employees could be considered to have been in employment immediately before the transfer when they had been dismissed 1 hour prior to the transfer. The House of Lords held that the employees would have been so employed if they had not been unfairly dismissed before the transfer. And this is my area of specialization as well. The House had clearly read in the additional words in the legislation to give the effect to and achieve the purpose of the EC directive. The aim of the legislation was to protect the employees in the case of a transfer of business. Another example, Pickstone against Freeman's plc. Miss Pickstone, the claimant, in this case was working as a warehouse operative. She claimed that her work was of equal value to that done by the male colleagues who were being paid £1.22 per week more than her. The House of Lords applied the purposive approach and ruled that Miss Pickstone was entitled to make a claim on the basis of work of equal value even though there was a male employee doing the same work as her. According to the court, the literal approach would have left the UK in breach of its treaty obligations to give effect to an EU directive. Recently, you might have heard in the UK that equal pay claim. In respect of this claim, there have been flurry of cases and a huge amount of legislation in relation to equal pay is still going through employment tribunals in the UK. Now let's look at the impact of Human Rights Act on interpretation in our next lecture.